Hi, everybody. It's Leslie with the New Mexico Small Business Development Center. I'm here with Anna Lena. We have a really great webinar today. I want to introduce everyone to Mr. Ian Alden. I hope I got that last name correct. He specializes in tax law and enjoys helping clients to maximize their tax efficiency through proper choice of entity or entities and strategically planned transaction. He has been admitted to the State Bar of New Mexico in 2015. He's represented individuals and small business clients in a wide variety of matters. Today will be the first part of a two-part series. We will have the second part Thursday at 12 o'clock, again with Ian Alden and I believe Nick Baker, Mr. Nick Baker. Today is business succession plans and buy and sell agreements. I want to tell everyone before we get started that I hope it's at the bottom of your screen, but at the bottom of my screen on the right-hand side, you will see a little button that says live transcript. We have enabled closed captioning, and if it's a little too much and you want to turn it off, if you'll click on that live transcript button, and I'm going to click on mine, you'll see three settings. The top one says hide subtitle. If you just click on that, it'll hide that closed captioning for you. So remember, that's on the right-hand side at the bottom, and it's a little button that says live transcript CC. Also, if you have any questions that you'd like Mr. Alden to answer for you, he said he's going to stop after each major section, but also he's going to address the questions at the end. So you'll see a Q&A. Just type your questions in there, and he'll be glad to answer them. So I will turn it over to Ian if you're ready.
Yep. Good morning, everyone, or I guess it's now afternoon. My name is Ian Alden. I'm happy to be running this seminar today. A few quick points of interest before we get started here. Here we've got a number of resources available specifically having to deal with COVID-19 that you might want to look into depending on your situation. Of course, you can always reach out to your small business development center liaison to get a better sense of some of these resources, but they're listed here in the slide deck, which I believe everyone will have access to at the end of this. If not, maybe take a screenshot so that you have these resources on hand.
Yes, they will have access after the presentation.
Great. So a few points of guidance before we get into this. Please mute your, I think that's supposed to be audio. Please mute yourself if your microphone is on for some reason. It shouldn't be since we're in a presentation mode. Make sure your Zoom ratio is set to fit window so that you can see everything that is being presented here. We'll be using the Q&A function to take questions. Just write down your question and slide number it relates to, or the slide topic if you don't have the number on hand. And I'm going to be taking questions throughout the presentation and then at the very end. So some things that will also be addressed in addition to the overall topic of the presentation, some of the other trainings that are on offer, some assistance you might be able to get through the small business, the SBDC, some of the training objectives for this seminar, and some other helpful information. So some upcoming trainings and assistance opportunities for you here. We've got the second part of this succession planning seminar on the 11th from 12 to 1. I'll be co-presenting that one with Nick Baker. So, definitely come to that one, even if you've already been to this one, simply because there's going to be a lot, there might be some overlap, but there's going to be a lot of new information in there, especially when it comes to things like financing a buy-sell agreement or, some of your other options there. It'll take a deeper dive into some of the issues that are presented today. But we've got presentations and seminars throughout the month, so be on the lookout for some of those. Okay, so I'm breaking down this presentation into three key parts. Inheriting a business, how does it work generally? what happens when you pass away? How does probate factor into it? The second part is wills versus trusts. I've had a lot of clients reach out to me over the last few years wanting, for example, to start a trust to own their house, own their business without ever really having a comprehensive estate plan in place. So we're going to talk about how you can make trusts work in the context of a succession plan. And then the last point is succession plans themselves. I know it seems a little counterintuitive to end with succession plans, but it's important to lay the groundwork for what a succession plan really is and what it does for you. So we'll talk about succession plans, not just for when you pass away, but when maybe you're ready to retire or do something else with your time and you want to make sure that your business stays going, or you want to make sure that you're getting the most you can for it. So we'll talk about some of those points as well. I'm going to make a few key points in this first topic here in terms of how a business is inherited. The first point I want to make is that your business is property in your hands. It's sort of odd to think of your business as, being functionally the same as a car or a house or some jewelry, but ultimately it is property that belongs to you. It's property that can stand to be inherited by your heirs or beneficiaries. Typically, when you sell, your interest in a business is considered gain on the sale of an asset, or assets in the case of a single member LLC. But for a multi-member LLC, for corporation, for an LLC tax as a corporation, you're holding a capital asset. Same with a partnership. So you could be looking at, if you ever sold it, capital gains treatment. When you sell a single member LLC that's just treated as a disregarded entity, or if you sell your sole proprietorship to someone, it's considered a sale of all the assets that the business holds. But whether it's one or many assets, the point is your business is an asset. And the reason I say that is because I get a lot of questions from clients who are going through estate planning, or just trying to tighten up asset protection strategies. They want to keep their LLC out of the reach of creditors. They want to keep their house out of the reach of their creditors by putting it in an LLC. And one of the big reasons that doesn't work as a strategy is because your LLC is itself property. So if you put your house or other assets into the LLC, that LLC might be subject to creditor liens or seizure just the same as your other property. So it's a very important point to understand as we lay the groundwork here. Your business, your ownership interest in your business, it's your property ultimately. The second thing I want to point out is that your property writ large is disposed of by your will. And what that means is, you look at your estate when you pass, you typically have a house in most circumstances, cars, jewelry, personal effects, objects of sentimental value, and you have your business, your shares in a corporation, your membership interest in an LLC. That's all property that gets roped into your estate and needs to be administered through your estate. And I say that because one of the biggest requests I get from people when I am helping them get started with their new company is, planning for succession. A lot of people ask me, well, can't we just write in the company's operating agreement or bylaws or other governing document of the company who receives the company? And the answer is ultimately no, because your interest in your company, again, is property. And that property would ultimately go to your heirs, your beneficiaries under your will, or under the laws of intestacy if you don't have a will. But that property can also be used to satisfy judgments of creditors of the estate. If, for example, your estate has $200,000 in debt and your only real asset is your LLC, the creditors are going to have a valid claim against the estate, probably, to go after the estate's assets, which includes the company. So if you were to dictate in your operating agreement that your LLC is going to pass automatically to someone, that could be in violation of the rights of the estate, of your estate's beneficiaries, of its creditors. And so it typically doesn't work. You need to think of your business as property that's going to be taken care of through your personal estate, much the same as your other property. Point number three, and this is a fun one. Management of your business during probate is complicated. Probate, if you haven't heard of the term before, it is the process. It can be kind of a lengthy process where your personal estate is being administered in accordance with your will or New Mexico law generally. There's a personal representative or an executor appointed who's going to oversee your estate, collect all the assets, and pay off the creditors, and then distribute what's left to your beneficiaries as you provide in your will. The process of probate can take anywhere from a few months to a few years, depending on how large your estate is, how much of it is liquid or easily liquidated versus how much of it is tied up in, for example, 5-year non-redeemable bonds, for example, things that aren't immediately convertible. So, you think of everything as going into your estate, including your LLC, for example. How does it get managed in the meantime? This is where, and we'll talk about this in section 3, but this is where your succession plan really needs to be focused and comprehensive, like multiple pieces of puzzle working together, because the executive of your estate is going to have the voting power for your shares of a corporation or your units of an LLC, for example. So your executor, the executive of your estate, will have the power to vote in instances where voting needs to happen. But your operating agreement, for example, could provide for someone else to step in as manager, particularly if your company has multiple owners. Usually in that situation, the surviving owner would step in as manager. The executor still has voting power, but the management of the company is seen to, which helps promote continuity. Usually if your personal representative is a close family member, your spouse, your kids, you don't want them to suddenly have to take on the management of your business, especially if they've never been involved before. So it helps to plan ahead for these sorts of situations, maybe having a trusted employee or an owner, someone who can step in to assume management responsibilities. So it helps when trying to wrap your head around this, it helps to look at a few case studies. These are a few examples of how things might play out in any given situation. I have to do that thing that lawyers do, where I caution you that these are gross simplifications of these sorts of situations. I mean, results may vary based on a number of factors that I just don't touch on in the case study. It's really meant to just give you kind of a base level understanding of how things play out in some set of circumstances or another. So let's look at the first case study here. We've got the owner of a single member LLC treated as a disregarded entity. That means the LLC has only one owner and it hasn't elected to be taxed as a corporation, either a C Corp or an S Corp, because by default, a single member LLC that doesn't elect to be taxed as a corporation is going to be taxed as what's called a disregarded entity. It's the same as a sole proprietorship. The owner reports all the profits and losses on his or her personal tax return every year, Form 1040 Schedule C. So that's what we're dealing with right here. So the owner of a single member LLC treated as a disregarded entity passes away. He doesn't have an operating agreement for his company, never created the document that governs how the company is run, how voting happens, things like that. And his will is not specific as to what would happen to the company. He's got a will, just leaves everything to his 3 children in equal measures. His spouse is predeceased him, spouse passed on before him. So we've got a situation where the owner's passed away, he has a will, no operating agreement, 3 children. What happens to the company here? To figure that out, we look at 2 things. We look at the will, and because there's no operating agreement, we look at the New Mexico Limited Liability Company Act, because the LLC Act, it provides for what's called default rules. It's just a set of rules and guidelines for the LLC's operation if there's no operating agreement. One of the reasons you have an operating agreement is because it's more specific as to how things should run in your company, and it also can supersede a lot of the provisions in the LLC Act. So it lets you customize things a bit. But there's no operating agreement here, so we look at the LLC Act and start from the ground up. As I mentioned earlier, the LLC is property to the owner, but more importantly here, the property of the LLC is treated as separate from the owner under the LLC Act. So let's say the LLC has a number of assets inside of it. The LLC as a whole, as a container, is treated separate from its owner. So, the owner's membership interest is treated as property of the owner, but the LLC's property is property of the company. So what's going to happen is the estate is going to take the LLC. The executor or personal administrator or personal representative of the estate has the right to administer the LLC. So again, they have the right to vote the shares, as it's called. They can vote on any key issues. Since it's a single member LLC, they would be able to administer it outright, making decisions as to how to proceed with the business, whether to keep it going or shut it down. Side legal note, the owner, when an owner passes away, they're treated as having what's called dissociated from the company. The estate stands in their shoes as the assignee until whoever gets to take the company under the will takes the company. So you fast forward a little bit, the estate goes through its probate process. And then at the end of that probate process, or at some time during it, the executor is going to have a lot of discretion because the will was not specific as to what happens to the company. It just, the will leaves all of the decedent's property to his 3 children. So the executor has a lot of latitude here. They can, distribute the company in equal measure to the 3 children. So the 3 children become 1/3 owners of the company. If, for example, you have a situation where maybe 1 or 2 of the children are involved, but not all of them, the executor could balance out the value of the estate and distribute the company to maybe 1 or 2 of the children and just give the 3rd child more in terms of other assets or compensation. The executor could also sell the company off with the proceeds less the executor's administrative costs distributed out to the heirs. Or lastly, the executor could just say, you know what? I don't want to deal with this. This company isn't going to be easy to sell. I'm just going to close up shop, sell off the assets, whatever I can get for them, and that's what the heirs are going to get. You see, the problem with this is that maybe you want one of these things to happen, but you weren't specific, and so now it's up to someone else to make the decision for you. That's why it's really important to have some specifics in your will. Skip on to case study number 2, where we're going to look at some similar situation, but some key differences. So we've got in this one, the owner of a multi-member LLC treated as a partnership, because a multi-member LLC or multi-owner LLC is treated by default as a partnership for tax purposes, unless it elects to be taxed as a corporation. So in this case, we've got a multi-member LLC treated as a partnership. One of the owners passes away. To be clear, not all of the owners, just one. The company has an operating agreement that has 2 key provisions that the owners insisted on when they drafted it. One states that it provides for who's going to receive each member's ownership interest upon their death. The operating agreement specifies that in this case, the deceased member's interest will go to their best friend. The other key provision in this operating agreement states that the surviving members will have the right to buy out the deceased member's interest from his successors. The deceased member, again, has no surviving spouse, but has 3 children who would inherit equally from their estate. What would happen here? Touching on some key points that I raised earlier, the deceased member's interest in the company is still treated as property of the owner, and the estate has a property interest in the LLC, notwithstanding the operating agreement. So you remember that provision in the operating agreement that said who the company is going to go to? Doesn't quite work that way. Because again, the estate has an interest in the LLC. The estate might have an interest in it for the heirs, but it certainly has an interest in it to make sure that the creditors get paid, the creditors of the estate. So that part of the operating agreement is probably not going to be enforceable. I've seen some circumstances where that provision in the operating agreement lines up with what's in the will, in which case, great. But the will governs here, the operating agreement doesn't. And you follow a situation like that to its natural conclusion. If the best friend were to somehow get a hold of those LLC interests, the estate could sue any number of people, including that best friend and a business partner, whatever, to try and claw back that ownership interest. So you really have to be careful in how you're handing these things off. The other part of the operating agreement, though, providing that the remaining members can buy out the deceased member's interest, is typically very enforceable. And one of the things we're going to touch on, not in this seminar, but in the one later this week, is how you finance things like that. We're going to talk about key man insurance and other financing mechanisms that would let the company do that when a member passes without financially burdening themselves at the time. It tends to be something of a win-win for the estate, which probably doesn't want to deal with the company, and for the remaining members who probably don't want to deal with the estate or the deceased member's children or spouse as business partners. So, that provision of the operating agreement is very common and it's typically enforceable. While that process is ongoing, however, the estate, again, the executor of the estate is going to stand in the shoes of the deceased member for voting purposes. So the other members are still going to have to deal with the estate as a presence in the company. And of course, to the extent the owners have fiduciary duties to one another, duty of loyalty, for example, to the extent it applies, that duty extends to the estate of the deceased member. So you really have to watch out and make sure, if you're one of those surviving members, that you're not doing anything untoward that would disadvantage the estate as a temporary owner of the company. So before I move on to wills and trusts, I'm going to look at the Q&As and see if we have any questions that I can answer before moving on. And again, we'll circle back at the very end of the presentation to take questions about anything. But let's see here. I don't
And
have.
I had a question. I had just 2 points on that.
Sure.
What if there is slide 11? Okay, what you had talked about. What if there are minor children? You had talked about that. What if there's minor children in this? And also, if you are inheriting a business and you don't have a will or something, how long would this process take?
Great questions. In terms of minor children, it can be a little hit or miss here. It gets into parts of probate law I don't really practice in, but when I'm devising an estate plan for someone and they have minor children who they want to take their business or to, reap the profits of the business, or maybe have the business sold for the benefit of their children, that's really where trusts come in. And I'm going to touch on that a little bit in the next section, but it's really important to have trusts in place for the benefit of minor children. If we're talking children who lack the capacity to administer the LLC and you don't have a will and don't have trusts in place, the laws of intestacy kick in, and there might end up through probate. The courts themselves might insist on the creation of a trust for the benefit of those minor children who would stand to inherit. For example, you're not going to hand off the ownership of an LLC to an 8-year-old. It's just not going to happen. And you're probably, hopefully, fingers crossed, not going to find a judge who does that either. Your next question having to do with how long it takes. I've seen probate take 3 months when there was a will in place. There wasn't a lot of complicated there wasn't a lot of complication with the assets the decedent had, bank account, some property that wasn't subject to liens or financing and anything like that. All of the heirs, the beneficiaries, got along fabulously. There was no dispute or controversy. That took about 3 months just because of the mechanics of going through probate. I have seen non-contentious probate just with complications like I said, financing. Banks are involved that have liens on houses and community property and whatnot. I've seen it take 6 months to a year, and I've seen contentious probate, which is the children don't get along, one of them's going to challenge the will or whatnot. I've seen those take 2 to 3 years. And meanwhile, the beneficiaries, the executor of the estate is keeping on top of the property. They're probably spending a small fortune in legal fees, but the heirs themselves probably aren't going to get a hold of any property until the probate is mostly resolved.
Thank you.
Mm-hmm. Keep in mind, I'm covering this because it's important to understand in the context of succession plans, but really a good idea if you ever have, questions about your unique situation, because everyone's situation is very unique in this regard. Reach out to an estate planning attorney, or reach out again to your SBDC liaison, who can point you towards some helpful resources to get you where you need to go. So on the topic of wills and trusts, and let me just check the time here. Okay, so on the topic of wills and trusts, there are two key parts of your estate plan that do different things. Wills dispose of your personal property. That's property you personally own in an orderly fashion. Trusts, by contrast, they're vehicles to administer and hand off property specifically given to the trust. Notice I've got that underlined because a trust does nothing for you if it has not been assigned property to administer. When you look at an estate plan as, a series of different pieces, lots of folks have trusts, but pretty much everyone should have a will. I can't think of a case where you should not have a will. There are plenty of cases where maybe a trust isn't really going to do anything for you, but everyone should have a will. Because, like I said, the trust deals with certain property, the will deals with literally everything else in your personal estate. So you want to make sure that it is in place. Because again, if you personally own your business and it's not handed off to a trust, it's your will that's going to govern what happens to that company for the most part. Whoops. So before I get to this case study, I just want to cover a little bit about what trusts are. There's two kinds of trusts. There's what's called revocable, REVOCABLE, also called a living trust. And then there's an irrevocable trust, IRREVOCABLE, irrevocable. The big difference is a revocable trust. It's something that you can put property into as the creator and take property out of. Typically, when we deal with LLCs and whatnot, we put them into revocable trusts so that the owner can take them out if they want to sell or convert the LLC. The owner will receive the income from the LLC through pass-through approaches, and the LLCs will be administered through the trust. Irrevocable, I've got a lot of people who are asking me about irrevocable trusts for their LLCs. I don't really recommend them in all but the most severe cases, because an irrevocable trust, once you put property into, it belongs to the trust for the benefit of its beneficiaries. You cannot take the property back out as the creator. So for most people, they want a level of flexibility with their LLCs and corporations that you're not going to get with an irrevocable trust. So when I'm talking about these case studies, I'm probably talking about the first kind, revocable or living trusts, where you have some flexibility, put stuff in, take stuff out. So looking at case study number one, Jim has a wife, 2 children, and no will. Jim passes on suddenly. What happens? New Mexico, just like it has an LLC Act that deals with LLCs that don't have operating agreements, we have what's commonly referred to as the laws of intestacy that deal with situations where the owners don't, or I'm sorry, where the decedents don't have a will. What typically happens, it's a one-size-fits-all approach that was created by the legislature. It really is created by a committee of uh, lawyers who drafted recommendations that the legislature adopted, but it really is a one-size-fits-all approach. The wife would typically inherit the marital community property, and then anything that's Jim's sole and separate property would be divided between the wife and two children according to a formula. It's pretty simple, which works for some people, not for others, but it also does tend to complicate probate, because if you have a will, it can be pretty simple to distribute property according to a will, especially if it just says everything to my wife or everything to my children. It does not work that way with the laws of intestacy, because first you have to figure out what those laws are. And then second, you have to figure out how they apply to your property, which means you're probably going to have to deal with a lawyer or at least some kind of uh, help service. So a will is going to make things simpler and quicker for your beneficiaries, your surviving spouse, your heirs, and what have you. But now let's look at case study number 2. And this is kind of important because it can illustrate what you could do with the trust here. Jim has a wife, 2 children, a will, and a trust that was set up to hold his business interests. Jim passes on suddenly. What happens? Um, when you have a trust, you name a trustee and you name a substitute trustee. Usually, when I set up these irrevocable trusts for business owners to put their businesses in, they themselves are the first trustee. The business owner is the trustee, so they can administer the business as trustee for the trust that owns it. Similarly, they can decide, okay, we're going to give this back to the grantor. Nice and simple. But then when the business owner passes, the trust document should specify who takes over as trustee. Usually it's the same person as the personal representative of the estate, but it doesn't have to be. I've seen trustees who are the trusted longtime business manager, while the surviving spouse is the personal representative of the estate. You can really get flexible and customize these trust documents. So the trust is going to administer the business, the substitute trustee will, um, until something in the trust triggers a distribution of the company to the beneficiaries specified in the trust. To be clear, the beneficiaries of the trust do not have to be the same as the beneficiaries of the will. For example, Jim has 2 children, but maybe he only wants one child to take the business, so he can specify that in the trust. But more importantly, and this is kind of touching on the question I just answered a few minutes ago, a trust doesn't have to terminate right after the creator passes away. Let's say Jim's 2 children are ages 8 and 11, and Jim wants the trust to own the company and manage the company for the benefit of the children until both children turn 21. And then he wants the children to get the company 50-50. You can do that in a trust. And so you can see to the needs and long-term care of other, of your beneficiaries. So, looking at why you use a trust, it's great for a business continuity plan. If the trust owns your business and then you pass and your substitute trustee knows how to run the business, there's not necessarily going to be a break or interruption in the operation of the business. Maybe the business just keeps running smoothly, which is what you really want. You can, again, designate a trustee who's not necessarily the executor of your estate. You can hold the business interest for years after passing. There's these things called rules against perpetuities, which if you Google it, it's every law student's nightmare. Rule against perpetuities is one of the hardest things we had to learn, because it limits how long a trust, for example, can operate after its creator passes. But to save you some time and grief, just know that you can create these things that last for decades after your passing. So you can really see to the needs of your beneficiaries, children, for example. Let's see here. there we go. Your children or disabled spouses or other beneficiaries, maybe elderly parents, people who need long-term care and who you don't want to leave all of your money to outright. Very common example in my estate planning practice, I make trusts to ensure that the creator's children have a certain amount of money to live on each year, but you don't give the children all the money because they will blow through it in a casino in Monaco. Client's words, not mine. So, trusts, there's a lot of reasons to use them, and they can be very powerful and flexible vehicles in terms of your overall succession plan, which we're going to talk about next. But before I get there, let's take another round of questions if anyone has any questions for me.
If anybody wants to raise their hand also, I can unmute the mic.
Okay, I guess I will move on to the next topic, which is succession plans. Now, when you think about a succession plan, you might Google it and see it defined in some very narrow terms as, the immediate handoff and continuity of operations for the business, for example, the plan that makes that happen. But in reality, succession plans, they can be a lot more complicated, and rightfully so, because as I just talked about, there's so many moving parts to govern how your company is dealt with in the event of your passing. For example, you've got the will, for sure. You've got a trust, if you go that way, a trust to, make sure that the company is administered properly without it having to go through probate. I forgot to mention that is an important part of trusts, by the way. Trusts are administered separately through probate. The property of a revocable trust can be used to satisfy the judgments of the estate. So, let's say your estate has $1 million of debt and you've got a company worth $250,000 in your living trust. Your estate can go after that company because the revocable trust isn't considered legally distinct from you for that purpose, for purposes of taxes and creditors. It would be considered part of your estate for that. But let's say that's not a situation that's going to impact you. Your debt to assets isn't that kind of redonkulous. You'll have a situation where you've got your trust administering your company. Your will is being probated over yonder, but the probate process doesn't really impact the trust or its running of your company. So, let's say you've got a trust that's doing that for you so that it's administering your business while your will is being probated and whatnot. You also have the operating agreement or bylaws in the case of a corporation to ensure that the company is being run the way you want it to by your successors. It's important to understand, the limits of that, obviously, because, your trustee or executor of your estate can vote your shares or units after you pass. And if the operating agreement allows them to amend or replace the operating agreement, they could do that. But, it matters more, I think, in cases where you have an LLC with multiple owners or a corporation or partnership with multiple owners, because then a good operating agreement or bylaws, it's going to protect those owners as well as the rights of your estate and beneficiaries and trust. So I look at an operating agreement as a key part of a succession plan, or at least something that needs to be done to make sure your succession is going to go off well. Another part of the succession plan, in my opinion, involves comprehensive financial and retirement planning. You want to make sure when you're ready to step away from the business and hand it off, that you have the financial means to do that. And you have the plan and strategy in place to let you do that for the long haul. And so we're going to look at a few examples of what that looks like and how your company might fit into your retirement plan. Because, through this presentation, I've talked about what happens when you pass away, but that's not the only situation where you're going to want a good succession plan. So So let's talk about retirement. And this is one I get a lot. A lot. I mean, I get small business owners who reach out to me because they're 60 or 70. One guy was 83, still running his business, and he just did not think he could retire without selling the company. And the truth is, it takes some creativity, but there are a lot of ways that you can ease yourself out of your company. For example, you might sell the company. You might sell it to a third party or to an employee or a manager or one of the other owners if it's a company with multiple owners. Uh, Sometimes you might bring on an employee as a part owner. I see this a lot where you bring the employee on as maybe a 5 or 10% owner. You gift them an interest so that it doesn't create any immediate tax implication for them. And then you have the company buy you out over a period of time, in a situation which sees the company pay you for your interest. It's a bit like a reverse mortgage, except a bit more above board, depending on the reverse mortgage situation. I don't know that much about reverse mortgages, but there's situations like that where the company itself can buy you out using its own earnings and profits, while maybe you stay involved to some extent, maybe you don't, but ultimately you hand it off to your successor employee, in situations where you want the employee to keep the business once you're out. Sometimes you want to use your company as an income generating retirement asset where you're hands off, you're not involved in the day-to-day administration. You've got some trusted employees or managers. Maybe you cut them in as part owners to give them a true vested interest in keeping the company going and growing and profiting. But you yourself are retired, but still generating profit, still enjoying profit from the company. There are more permutations of this retirement scenario than I can count on two hands. I mean, I worked on three last month that were very different from one another. So it's important again to look to your resources and figure out, okay, what are my next steps? What are my priorities? What's my situation? What's going to work for me? Reach out to a good estate planning or business succession attorney, chat with the SBDC. I know that they've got a lot of great resources that can help you, if not directly or with self-help, then they can certainly point you in the right direction. Um, Here's an example, based on kind of a true fact pattern I dealt with maybe a year ago. Janet owns her own medical supplies reseller company. She's approaching 60. She wants to step back from the active day-to-day involvement. She's got kids and grandkids she wants to spend more time with, and she wants to travel. She doesn't want to sell the company outright. She built it up, with her spouse. It's got a lot of sentimental value, and she's hoping it can fit into her retirement. She considers selling it if the price were right, but doesn't want to, partly because she expects that the value is going to go up in the next few years. In this specific case, because the company provided a lot of COVID-19 testing and mitigation supplies, and she expected that if COVID became endemic, the company would just grow in value. So she didn't want to sell it. And you look at some options that she could have explored. These are options that I went over with her. Um, she could, like I said, appoint one of her best employees as the manager because she had a good team working under her, and empower them to handle day-to-day operations while reserving some strategic decisions to herself. This is always the balance my clients have a very hard time striking, because it's very hard to run your own company for 20 or 30 years and then step back all at once. And so, a gradual phase out uh, could be in order, where you hand off the day to day, but you're still involved in the big decisions, and you're still keeping on top of things enough to know if, for example, your manager is mismanaging the company, or, and I saw this 2 years ago, embezzling from the company while you're semi-retired. Um, you know, Different levels of handoff for different people. Everyone is different. I suggested as a good incentive to give the manager an ownership interest, because you don't want a situation where the manager doesn't have skin in the game and then manages the company for 2 or 3 years well, grows it well, and then goes and takes a better offer elsewhere. Give them some interest in the company to keep them invested and really help them grow the company, so that you profit, they profit, it's a win-win. Janet could also hire a business broker to explore sales options. Business brokers, a lot of folks don't know they exist, but really they're kind of like realtors in a way. They handle business sales. There's a market for businesses being sold right now, and so a business broker can help you get a valuation lined up and figure out what your business is worth, help you sell it. If you're inclined to sell the business, it could be to a third party, maybe via a broker, or it could be to your own employee if they're interested in buying you out. There's a number of ways your employee or third party could get financing for it. There's a number of SBA loans that work for buying out the entirety of a business interest. There's private lender financing. You could offer them seller financing where they pay you over time, or some combination of the above. I literally did a deal not too long ago that involved all of the above. It's a little weird mixing SBA and private lender financing because of strict SBA regulations and lien priorities, but they managed to thread the needle somehow and make that work. But there's plenty of options for financing. And again, grant the ownership a small ownership interest, and then have the company itself buy her out over time, leaving that employee manager as the only remaining owner. This is a surprisingly popular option for people who don't, who want to get paid over a period of time, but they don't want to saddle their employee with the immediate tax burden of getting the company or some large part as a gift, and they don't want the owner to be personally liable if the company goes under. Different sellers have different priorities here. Some would want the employee to be personally liable. Some would say, no, I don't think that's fair to the employee. We're going to leave the risk, I'm going to assume the risk that the business doesn't survive. So, looking at that with a little more depth, she decided to go with that option. Give her employee 10% and have the company buy her out over a period of 5 years. How does that work? Janet can either gift or sell the ownership interest to the employee. It's important to understand with gifting that there's what's called an annual gift tax exclusion. It's an amount that you can gift to any person in a year, below which you would not have to deal with any gift tax on what you're giving them, and they wouldn't have to deal with any income tax on what they're giving them. That amount is $15,000 per person per year. When last I checked, it may have gone up in 2021. I would have to double check. It goes up a little bit each year typically, but not by much. You can gift amounts larger than that, but it comes out of your lifetime combined estate and gift tax exclusion, which when last I checked was about $11 million per person, thanks to the Tax Cuts and Jobs Act. So I've never seen any of my clients really get up there to where they ever have to pay gift tax on what they're giving. It's just, you have to look at some gifts in the context of your overall estate, because what you don't want is to gift such a large amount that when you pass, you have to pay estate tax on the value of your estate because you used your exclusion gifting things. Again, $11 million, I've never seen it be an issue for people, especially my small business clients, but things to be aware of. Alternatively, Janet can sell the ownership interest to the employee. One way or the other, you gift them the small ownership percentage, in this case, 10%. Make sure you have a good operating agreement, because that is the governing document by which the company is run, by which the owners or members are governed, which would include both Janet and the new member at that point. If it's a corporation instead of an LLC, you'd want bylaws and a shareholder agreement to accomplish the same thing. Then Janet would enter a buyout agreement with the company itself. And this is where things can get really interesting and, again, customizable. In this case, Janet said, pay me over 5 years straight line, 60 equal payments. Janet retained a security interest in the company's assets for the whole time that the payments were outstanding. But Janet stepped back from being a member of the company as soon as the buyout agreement was signed. So the member became the manager became the only technical owner of the company at that time, with Janet having a lien on the company. But because of that, and because this was such a hands-off approach for Janet, she insisted that the remaining employee owner personally guaranteed the obligations of the company to pay Janet for her ownership interest. So, that was a level of security that made Janet comfortable. Some people would insist that the employee owner themselves buy out the interests, offering a personal guarantee or other collateral. Some folks insist on less and say, I don't need a personal guarantee from the employee owner. I trust that they're going to run the company well and the company will pay me, but they still take a security interest in the company's assets. You should have some security interest to prevent, for if nothing else, the owner from closing up shop, selling the company, and then disappearing into the dead of night. So, this is something you want to talk to a good lawyer about, typically, to make sure that you're structuring this in a way that works for you. As I said, they're highly customizable. Another situation I deal with quite regularly is where the owner, they want to be bought out by the company, but what they do is they put all of their ownership interests into escrow, and then have the escrow hand off those ownership interests over a period of 5 years, so that the the retiring owner stays involved. They can vote the shares or units held in escrow during that time. And so they're effectively staying on, and then they hand off ownership little by little until finally, when the last payment has been made, they drop down to 0% ownership interest, and then they're out. That can get a little complicated, but it does have the benefit of letting you gradually phase out and retire in a way that's fair and equitable, and makes sure that the company and the new owner get what's due to them. So again, not to harp on this, but very flexible. So again, every business owner's needs and priorities are unique to them. It's important to have a good and proper succession plan. It's also important to understand how to finance some parts of the succession plan. Like I said, the buyout of a deceased owner or partner or shareholder in a multi-owner company. It's very important to understand how to finance that. So come back on the 11th and learn more about that. Nick's going to have a lot to offer in that realm, and I'll be here to answer questions. Next steps, I would strongly suggest reaching out to your SBDC liaison and take it from there and figure out what resources are available to you, because the sooner you start on this, the more orderly the transition. If for whatever reason it happens suddenly, the last thing you want is for everyone else to be scrambling to figure out what to do with this company, because you put off getting a succession plan in place and then it was too late. So I'm going to go back to the Q&As. I've got 2 questions in here.
You want me to read the question to you, or?
I'll read it.
Okay.
So my first question, slide number 21. Does an operating agreement have to be administered by a third party? I've seen these as fee for service. As a micro business, single party LLC, is there a way to create this agreement on my own, or do I need to hire this out? Thank you. Okay, great question. I'm going to go back to slide 21. So the operating agreement, it might help if I clarify what the operating agreement is. The operating agreement, it's the governing document of the company itself. So if you had 3 owners of a company, for example, the operating agreement spells out how they vote, how profits are allocated and distributed between them, same with losses, what the company is there to do, what duties of loyalty the owners have to each other, and so on. It's very important for a multi-member LLC to have an operating agreement. Um, they're not administered by a third party. They're just there for to govern how the members deal with each other, how the owners of the LLC deal with each other. And so they have to act in accordance with the operating agreement because it's basically a contract between them as owners of the company and the company itself. When an owner doesn't abide by the operating agreement, typically you would try and resolve it maybe informally through a mediator, but ultimately, if you need to, through the court or through arbitration. A lot of operating agreements have binding arbitration clauses, but that's kind of how you deal with them. As a micro business, single party LLC, is there a way to create this agreement on my own, or do I need to hire this out? What I will tell you is that I have yet to see an operating agreement created by a business owner that offers any kind of real legal protection. I will tell you without getting specific because I really can't recommend specific services or providers, but there are things out there that let you create a customized operating agreement. There are operating agreement generators. You can find them online. You answer a series of questions and it kind of creates a document for you based on your answers to those questions. They're usually pretty affordable, nowhere near what you would pay an attorney to draft one themselves. You can often find them for under $100. Again, reach out to the SBDC. They might be able to point you in the direction of one of these products, or help you find them. Or they can point you towards me and I can point you towards them, whatever works really. I can't plug a specific product, but it's important to know that you do have options out there. And I'd probably recommend looking at them before trying to create it on your own, because an operating agreement has limited impact when it's a single member LLC. Maybe it binds the executor of your estate a little bit, and they could always vote to change it as the only owner. It really comes into play more where you've got multiple owners. Then the next question, does one set a buyout price by the surviving partner ahead of time, or is the value of the company determined afterwards? And if the latter, how is that calculated? Agreement between trustee and surviving partner, or external business valuation or other method? Great question. Fantastic question. This is something you can provide in the operating agreement, and I highly recommend you do. I typically include it in just about all the ones I draft. It can be as simple as hiring an outside valuator, and if one of the one of the parties doesn't like the valuation, they can personally commission another valuation. Or you could specify a valuation in advance. The problem with specifying a valuation in advance is that values change over time. So, if you make a company and you provide a dollar amount in year one, and then the company goes gangbusters in year 5 and grows exponentially, you probably don't want your estate bound by the valuation in year 1, because they would be buying the company for pennies on the dollar compared to what it's really worth. So my recommendation is almost always to provide a valuation methodology in your operating agreement and provide who is going to make that calculation. Typically an accountant, a neutral accountant, maybe the accountant who's done the company's bookkeeping and taxes. Again, there's a number of ways to customize it, but the more you think through this and the better you flesh it out in the operating agreement, the better, because then you can also, you can provide, for example, that you get a revaluation every few years and adjust your key man policies accordingly, which again, we'll talk about on the 11th, but those two things fit together very closely.
I also did want to mention that when you were talking about operating agreements,
Mhm.
we do have a pre-recorded on-demand webinar that was presented last week up on our website if anyone is interested in revisiting that. And then that will transfer, from what I understand, Annalena, to our YouTube channel. Is that correct?
Yes, that is correct. And I will send through the link for the YouTube channel right now. I actually just sent through some additional links in the chat. That includes our email address, a link to where you can sign up for additional counseling should you have questions, and a link for the live and on-demand webinars that we have going on currently. I will also send you an email to provide you with the on-demand link for this webinar and information on upcoming webinars, as well as the presentation slides. So if you have any questions, go ahead and email us at nmsbdcwebinars@sfcc.edu.
Got one more question. Do I have a minute to answer it, or are we?
Oh, yes,
Absolutely.
definitely.
Okay, so one more question. How do you determine the value of a business? So fun fact, as an attorney, I really can't provide a specific methodology. It's really not in my wheelhouse. Accountants typically value a business, and there's a number of IRS approved methodologies. There's a handful of them. They usually look at the value of the assets of the business. So if it's got equipment for what or whatnot, you get the real fair market value of that. You look at revenue. You often apply some multiple of revenue or profits, look at how much it's bringing in the last 3 years, or for the next 3 years. There's a number of ways of doing it, and so that's why it's important, like I said, when you have a multi-member LLC, to agree on the methodology in advance, because for example, if you're using a multiple of revenue, you want that agreed upon so that the surviving owners don't say, no, this valuation is way too high, I disagree with how you're doing it. But great question. I'd say chat with your accountant to figure out what a good methodology would be there. Any other questions?
I think that's our last question for today.
All righty. Well, thank you all so much for coming. Let me go ahead and stop sharing my screen.
And we will be back with everyone, with Mr. Ian Alden and Mr. Nick Baker this Thursday at 12 o'clock for part 2. Do you want to say anything, Ian, about part 2?
Again, there's a little bit of overlap, but there's going to be a lot that's new. So
Okay.
if you are curious and want to know more about succession planning or the financial part of it, definitely stop on by. I think it'll be worth your time.
Okay. That's
Thank
it
you
for
so much.
today. See you next time.